Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. Hey guys, just me. Today we're going to bring you part 2 of our 2-part release of The Queen and Golden. This one's a little different, so if you want to hear the dissenting opinion and what me and Zach thought about the case, head on back to the previous episode. Zach's about to bring you the majority decision, which appears second in the written version. Enjoy!
The following reasons are delivered by Justice Leroux Dubé. I concur with Justice Bastarache, except I would wish to reiterate the view I expressed in The Queen and Stillman at paragraph 167, that one factor in assessing the reasonableness of a relatively intrusive search, such as a strip search carried out in this case, is the existence of reasonable and probable grounds to justify the search. In my view, the factor was established in this case. Nonetheless, I agree the second search violated Section 8 of the Charter of Rights and Freedoms for the reasons articulated by Justice Bastarache. The judgment of IACOBUCCI, Major, Binney, Arbour, and Labelle was delivered by Justice IACOBUCCI and Arbour. 1. Introduction. The constitutional right to privacy requires that unjustified searches by the state be prevented. Accordingly, our court has held that prior authorization, where feasible, is a precondition for a valid search and seizure. At the same time, the power to search, quote, incident to arrest, end quote, has developed as a long-standing exception to this customary rule. As a concept that has evolved at common law, the search incident to arrest power has been framed by nebulous parameters. This court has, however, taken important steps toward defining the nature and scope of this power within Canadian law. As a result, it has been established that this search power may include the authority to fingerprint or conduct a, quote, frisk, end quote, search of an arrested individual, see respectively the Queen and Bear, Coultier and Langlois. It may also authorize the search of a motor vehicle driven by an arrested person, see the Queen and Castlake. On the other hand, it does not entitle law enforcement authorities to conduct more invasive searches of the person, with a view to obtaining bodily samples as evidence, see the Queen and Stillman. Whether the search incident to arrest power is broad enough to encompass the authority to strip search an arrested individual is the question before us, and is one that has never been put directly in issue before this court. In addition, an issue arises as to whether the common law, if it includes the power to strip search as incidental to an arrest, is reasonable. Finally, the court must address whether the strip search conducted in the instant case was carried out in a reasonable manner. For the reasons that follow, we are of the opinion that the common law search incident to arrest power does include the power to strip search. At the same time, this power is subject to limitations, which are discussed below. The prerequisites for and considerations surrounding the conduct of a valid strip search seek to balance the competing interests of valid law enforcement goals on the one hand and individual privacy rights on the other. Given the proportionality created by these criteria, we conclude that the common law is reasonable. However, in the present case, the strip search of the appellant did not meet the requirements for a valid strip search incident to arrest. This being so, we find that the strip search to which the appellant was subjected was unreasonable and violated Section 8 of the Canadian Charter of Rights and Freedoms. Accordingly, in all of the circumstances, we would allow the appeal. 2. Factual background. On January 18, 1997, in an effort to detect illegal drug activity in an area where trafficking was known to occur, officers from the Metropolitan Toronto Police Force set up an observation post in an unoccupied building across from a Subway sandwich shop that was approximately 70 feet away. From this vantage point and through the use of a telescope, one of the officers manning the observation post, Constable Theriault, observed the appellant, a black male, who was in the shop. Constable Theriault testified that he had a clear view into the shop and saw 2 transactions in which persons entered the shop and received a substance from the appellant. The officer testified that he saw the appellant take the substance from the palm of his hand with his thumb and forefinger and that the substance was white. He further testified that, given the place where this transaction occurred, the manner in which it took place, and the color of the substance, he believed the substance was cocaine. After the second transaction, Constable Terrio communicated with 5 other police officers involved in the operation who were not stationed at the observation post, the quote, takedown, end quote, members of the team. He gave them descriptions of the persons involved, including the appellant. Given what he had witnessed, Constable Terrio believed that the appellant was trafficking in drugs, and he instructed the takedown officers to arrest the appellant. When the takedown occurred, the officers entered the shop and arrested the appellant for trafficking in cocaine. 2 other individuals in the shop were also arrested. During the arrests, the police found what they believed to be crack cocaine under the table where one of the suspects was arrested. Constable Ryan, one of the 2 officers who first entered the shop and the officer who arrested the appellant, also observed the appellant crushing what appeared to be crack cocaine between his fingers. Following the arrest, Constable Ryan conducted a quote, pat-down, end quote, search of the appellant and looked into his pockets. He did not find any weapons or narcotics. This officer then decided to conduct a visual inspection of the appellant's underwear and buttocks. Constable Ryan obtained from the shop's employees the key to a door leading to the basement where public washrooms were located. On the landing at the top of the stairwell, Constable Ryan undid Mr. Golden's pants and pulled back the appellant's pants and long underwear. Looking inside the appellant's underwear, he saw a clear plastic wrap protruding from between the appellant's buttocks, as well as a white substance within the wrap. Constable Ryan testified that when he tried to retrieve the plastic wrap, the appellant hip-checked and scratched him, so that he lost his balance and almost fell down the flight of 14 stairs. Constable Ryan subsequently pushed the appellant into the stairwell face first. Concerned that the landing was not a safe place to continue the search, Constables Ryan and Powell escorted the appellant to a seating booth at the back of the shop. Patrons remained inside, were asked to leave, and the front door was locked. However, the other 2 arrested suspects, 5 officers, and the shop's employee remained inside. The officers forced the appellant to bend over a table. At this point, the appellant's pants were lowered to his knees and his underwear was pulled down. His buttocks and genitalia thus were completely exposed. According to the evidence, the partitions between the booth and the shop were high enough to block the view from the outside of the part of the shop where the search was conducted. The employee of the shop testified that passerby would not have been able to see what was taking place inside, but someone, quote, if looking carefully by the side of the window, end quote, would have been able to see the appellant's leg. Inside the shop, the officers tried to seize the package from the appellant's buttocks, but were unsuccessful, given that the appellant continued to clench his muscles very tightly. Following these attempts, the appellant accidentally defecated. The package, however, did not dislodge. Constable Powell then retrieved a pair of rubber dishwashing gloves from the shop's employee, put them on, and again tried to remove the package. According to the testimony of the shop's employee, these gloves were used for cleaning the shop's washrooms and toilets. By this point, the appellant was face down on the floor, with Constable Ryan holding down his feet. The officers instructed the appellant to let it out and to, quote, relax. Finally, Constable Powell was able to remove the package once the appellant unclenched his muscles. It contained 10.1 grams of crack cocaine with a street value of between $500 and $2,000. The appellant's pants were pulled up and he was placed under arrest for possession of narcotic for the purpose of trafficking and for police assault. The appellant was then brought to 51 Division, located about a 2-minute drive from the Subway shop. He was strip searched again at the police station, fingerprinted, and detained pending a bail hearing. On a voir dire hearing, the appellant applied to have the evidence obtained from the search excluded under Section 8 and 24 of the Charter. The application was denied and the evidence was admitted. The appellant was found guilty by jury of a possession of a narcotic for the purpose of trafficking, but acquitted on the police assault charge. He was sentenced to 14 months imprisonment, which he had served by the time this case was before our court. The Court of Appeal for Ontario dismissed the appellant's appeal from his conviction and sentence. 3. Relevant constitutional provisions. The Canadian Charter of Rights and Freedoms, Section 8. Everyone has the right to be secure against unreasonable search or seizure. Section 24, Sub 1. Anyone whose rights or freedoms, as guaranteed by this charter, have been infringed or denied may apply to a court of competent jurisdiction to obtain such remedy as the court considers appropriate and just in the circumstances. sub 2, where, in proceedings under subsection 1, a court concludes that evidence was obtained in a manner that infringed or denied any rights or freedoms guaranteed by this charter, the evidence shall be excluded if it is established that, having regard to all the circumstances, the admission of it in the proceedings would bring the administration of justice into disrepute. 4. Judicial history. A. Ontario Court General Division. In a judgment delivered orally on a voir dire, Justice McNeely stated that he was being asked to rule on whether the appellant's charter rights had been breached by reason of an unreasonable search, and by reason of a violation of his privacy rights in the course of that search. Moreover, the court was required to consider whether it ought to exclude from the evidence the material that was seized during the search. Justice McNeely stated that it is, quote, beyond question, end quote, that a search incident to a lawful arrest is an exception to the general rule that a warrantless search is prima facie illegal. Referring to this court's decision in Stillman, he noted that 3 conditions must be satisfied in order for a search to be valid under the common law power of search incident to arrest. 1. The arrest must be lawful. 2. The search must have been conducted as an incident to the lawful arrest. And 3. The manner in which the search was carried out must be reasonable. In regard to the first question, Justice McNeely held that an officer is entitled to arrest someone whom he or she believes on reasonable and probable grounds has committed an offense. In this case, the police had an operation underway that provided visual observations of the appellant engaging in 2 transactions in an area known for drug trafficking. In this regard, Justice McNeely stated at paragraph 9, the nature of the activity, the small quantity apparently involved, the manner in which it was handled, the color of the substance, the locale in which it occurred, all of these would provide an objective basis on which the officer could found a belief, which he did form, on those reasonable and probable grounds that trafficking had occurred. Moreover, the arrest took place immediately after the second transaction and was based on information and descriptions provided by Constable Theriault, who was stationed at the observation post and had witnessed the transactions through a telescope. Thus, not only did this officer have reasonable and probable grounds for believing the appellant committed an offense, but so did Constable Ryan, the arresting officer on the quote, takedown, end quote team. With respect to the second question, Justice McNeely held that the search was conducted as an incident to the lawful arrest. Given that the appellant was arrested for drug trafficking, it was reasonable for the officers to believe that narcotic substances might be found on his person. It was not only necessary and reasonable that the appellant be patted down to make sure that safety concerns were satisfied, but also that a search be made to see whether there was evidence that should be preserved for use at trial. Justice McNeely thus stated at paragraph 20, so having regard to the offense for which the arrest was made and the need to preserve evidence, I am satisfied that it is clear that the second requirement, I am satisfied that it was a search incident to a lawful arrest. In regard to the third and final requirement, Justice McNeely found that the police search was reasonable and did not attract a charter violation. In this regard, he reiterated that the arrest was for drug trafficking, and emphasized the importance of obtaining and preserving evidence for the purpose of trial. Justice McNeely also stated that, if the appellant had relaxed and not attempted to retain the package, the search could have been much shorter and less intrusive. Finally, he stated that although the search took place in a restaurant, the officers conducted it at the back of the store, and the evidence was that passerby outside would not have been able to see it take place. Finding that the search was reasonable and did not violate the appellant's right to privacy, Justice McNeely held that the evidence obtained from the search would be admissible at trial. He thus concluded his reasons for judgment as follows at paragraph 26. I am satisfied that having a regard to the nature of the offenses on which the accused was arrested and the need to preserve evidence and the non-cooperation of the accused, that the officers acted in a reasonable manner. Accordingly, I am satisfied that the search in question was a search incident to a lawful arrest carried out in a reasonable manner and therefore was not an unreasonable search or an undue invasion of the privacy interest of the accused, and for that reason the results of the search will be admitted into evidence. B. Court of Appeal for Ontario. Justice McNeely's ruling was unanimously upheld by the Ontario Court of Appeal. The entire judgment of Justice Osborne stated, Justice McNeely correctly set out the applicable legal principles. He found as a fact that the appellant held the bag containing the cocaine in his buttocks. This was therefore not a body cavity search case. We see no basis upon which to interfere with this finding, or any of the other findings of fact made by the trial judge. We agree that there was no Section 8 violation in the circumstances, and in doing so, we accept that the trial judge's reason on the Section 8 issue. The appeal is dismissed. 5. Issues. This appeal raises 2 issues. 1. Did the Court of Appeal for Ontario err in concluding that the strip search of the appellant did not violate Section 8 of the Charter? And 2. If the strip search of the appellant violated Section 8 of the Charter, would the admission of the evidence bring the administration of justice into disrepute under Section 24(2) of the Charter? 6. Analysis. A. Introduction. This court has held that a search will be reasonable within the meaning of Section 8 of the Charter where 1. It is authorized by law, and 2. The law itself is reasonable, and 3. The search is conducted in a reasonable manner. Applying this analytical framework to the present case, the court must address the following questions. 1. Was a search authorized by law? 2. Is the law itself reasonable? And 3. Was the search conducted in a reasonable manner? If these questions are answered in the affirmative, there will be no Section 8 violation. Conversely, if any of the questions is answered in the negative, then the strip search will violate Section 8 and will be necessary to consider whether the evidence obtained as a result of the search should be excluded pursuant to Section 24(2) of the Charter. Applying this analytical framework to the present case, the first question is whether the common law of search incident to arrest authorizes the police to conduct strip searches. If it does, the next question is whether the common law is reasonable. If the strip search was authorized by law and the law is reasonable, the final question is whether the strip search of the appellant was conducted in a reasonable manner. This court has emphasized on many occasions the need to strike the appropriate balance between the privacy interests of the accused on the one hand and the realities and difficulties of law enforcement on the other hand, most recently in the case of the Queen and Araujo. Similarly, in the present case, an appropriate balance must be achieved between the interest of the citizens to be free from unjustified, excessive, and humiliating strip searches upon arrest, and the interests of the police and of society in ensuring that persons who are arrested are not armed with weapons that they may use against the police, themselves, or others, and in finding and preserving relevant evidence. The appellant submits that the term, quote, strip search, end quote, is properly defined as follows: the removal or rearrangement of some or all of the clothing of a person so as to permit a visual inspection of a person's private areas, namely genitals, buttocks, breasts in the case of a female, or undergarments. This definition, in essence, reflects the definition of a strip search that has been adopted in various statutory materials and policy manuals in Canada and other jurisdictions. In our view, this definition accurately captures the meaning of the term, quote, strip search, end quote, and we adopt it for the purpose of these reasons. This definition distinguishes strip searches from less intrusive frisk or pat-down searches, which do not involve the removal of clothing, and from more intrusive body cavity searches, which involve a physical inspection of the detainee's genital or anal regions. While the mouth is a body cavity, it is not encompassed by the term body cavity search. Searches of the mouth do not involve the same privacy concerns, although they may raise other health concerns for both the detainee and for those conducting the search. Applying this definition of strip search to the facts, the appellant was subjected to 3 strip searches in the present case. The first strip search occurred in the stairwell when Constable Ryan undid the appellant's trousers, pulled back the long underwear the appellant was wearing, and looked down the long underwear at the appellant's buttocks. The second strip search occurred in the back of the restaurant, at which point the appellant's pants and underwear were pulled down to his knees while the officers tried to seize the package from between the appellant's buttocks. This second strip search also involved the police officers using rubber dish gloves to forcibly remove the package containing the cocaine from between the appellant's buttocks. This physical contact with the appellant's buttocks in the course of the second strip search places this search farther along the spectrum of intrusiveness than the first search, although on the evidence it falls short of being a body cavity search. The third strip search occurred at the police station. B. Did the Court of Appeal for Ontario err in concluding that the strip search of the appellant did not violate Section 8 of the Charter? 1. Does the common law search incident to arrest power include the power to strip search? It is clear that the common law in Canada recognizes the power of police to search a lawfully arrested person for the purpose of seizing weapons or evidence that may be in his possession. What is not clear, however, and what must be decided in this case, is the scope of this power to search incident to arrest. Specifically, does the common law authorize strip searches, and, if it does, are there any restrictions at common law on the power to conduct such searches? In considering whether the common law in Canada authorizes strip searches carried out as an incident to arrest, and, if so, whether the common law is consistent with Section 8 of the Charter, it is helpful to review the law concerning warrantless personal searches in the United Kingdom and the United States, as well as the case authorities in Canada, both before and after the enactment of the Charter. A. United Kingdom. The common law power of police officers to search a person as incident to arrest is a long-standing principle in English common law. However, the practice of carrying out such searches predates the common law authority for doing so. The tolerance of such searches appears to be attributable to the historical tolerance of intrusive acts towards persons accused of crimes, as well as the fact that most objects seized upon arrest, such as bags of coin or weapons, could be found without any lengthy personal search. The first reported cases in which individuals challenged the legality of personal searches appeared in the 19th century. In Leah and Cole, in an action against police for assault by an individual who was arrested, searched, beaten, and locked in a cell overnight for drunkenness, Justice Williams made the following comments about the common law search power at page 332. With respect to searching a prisoner, there is no doubt that a man, when in custody, may so conduct himself, by reason of violence of language or conduct, that a police officer may reasonably think it prudent and right to search him, in order to ascertain whether he has any weapon with which he might do mischief to the person or commit a breach of the peace. But at the same time, it is quite wrong to suppose that any general rule can be applied to such a case. Even when a man is confined for being drunk and disorderly, it is not correct to say that he must submit to the degradation of being searched, as the searching of such a person must depend on all the circumstances of the case. In Bessel and Wilson, decided in the same year as Leah, Justice Campbell criticized the searching of the plaintiff at the station house and made the following general comments about when it is appropriate to search a prisoner at paragraph 52. It is often the duty of an officer to search a prisoner. If, for instance, a man is taken into the commission of a felony, he may be searched to see whether the stolen articles are in his possession, or whether he has any instruments of violence about him, and, in like manner, if he be taken on a charge of arson, he may be searched to see whether he has any fireboxes or matches about his person. In the Scottish case of Adair and McGarry, the power to fingerprint an accused was held to be encompassed by the power to search incident to arrest. The court also indicated that stripping an accused for identification purposes could be justified at common law. See at pages 487 to 88. As regards undue invasion of the personal rights of the accused, one must have a sense of proportion. Certain it is that in practice, hitherto unchallenged, a person who is suspected of a crime may be brought, with reasonable violence in the event of his resistance, to the police station, that he may be paraded for purposes of identification, that he may be stripped, and that he may be searched for any incriminating natural or artificial mark upon his person. All these things are done with a view to establishing the identity of the suspect. The power of search and seizure incident to arrest was considered more recently in England in the case of Linley and Rutter, and in the Queen and Naylor. Both cases involved searches of female detainees at the police station carried out by female officers, and the removal of articles worn by the detainees. In Lindley, the article removed was a brassiere. In Naylor, the officer removed the detainee's earrings, rings, and necklace. In both cases, it was a matter of police policy to remove the items in question. The detainees in both cases resisted the search and seizure and were charged with assaulting a police officer. In Lindley, the defendant successfully appealed her conviction for unlawfully assaulting a police officer. The court concluded that, as the search and removal of the brassiere was not justified, the defendant was entitled to use reasonable force to resist and the assault charge could not stand. In Naylor, the trial judge directed the jury to return a verdict of not guilty on the basis that the police officers did not have the right to search the plaintiff and remove her jewelry, and that the defendant was therefore entitled to resist in the way that she did. The common law power to search arrested persons is expressed as follows in Halsbury's Laws of England, 4th edition, volume 11, 1976, at para 121, quoted in Lindley at paragraph 665. There is no general common law right to search a person who has been arrested, but such a person may be searched if there are reasonable grounds for believing 1. That he has on his person any weapon with which he might do himself or others an injury, or any implement with which he might effect an escape, or 2. That he has in his possession evidence which is material to the offense with which he is charged. What emerges from the cases above is that while the power to conduct warrantless searches as an incident to arrest did exist at common law England, it was also subject to some limitations. Specifically, the cases suggest that the power is limited to searching for weapons or for evidence relevant to the offense for which the individual was arrested. These limitations on the scope of the power to search incident to arrest suggest a concern with balancing the privacy rights of the arrested person against the duty of the police to protect themselves and others against any weapons that may be in the detainee's possession and to preserve and seize evidence in furtherance of their role enforcing the criminal law. The common law power to carry out a personal search upon arrest in England has been superseded by the statutory powers of search set out in the Police and Criminal Evidence Act 1984. The 4 main categories of search under the PACE scheme are the quote, superficial end quote, search, the quote, full end quote, search, the quote, strip search, and the quote, intimate search. Superficial searches do not require the suspect to remove any indoor clothing, while a full search may involve the removal of clothing but does not involve the removal of underclothing. A strip search, which is defined in Annex A to PACE Code of Practice C as, quote, a search involving the removal of more than outer clothing, end quote, may only be carried out in compliance with the rules relating to strip searches set out in the PACE Code. Such a search must always be carried out by a person of the same sex as the person being searched, out of sight of anyone of the opposite sex and anyone who need not be present. Normally, 2 people must be present in addition to the person searched. Although the search involves the removal of all clothing, it should be done in such a way that the person is never completely undressed and should be conducted as quickly as possible. While a visual inspection of genital and anal areas may be conducted, no physical contact may be made. If objects are discovered in any body orifice other than the mouth and the person refuses to hand them over, their removal would constitute an intimate search, which must be carried out in accordance with the rules pertaining to intimate searches. A quote, intimate end quote, search under the PACE is analogous to a body cavity search. It involves a physical examination of a person's body orifices other than the mouth. Intimate searches are only permitted under the PACE where the police have a reasonable grounds for believing that the detained person is concealing a weapon or that the person is concealing a listed drug that he intended to supply to another or to export, and that an intimate search is the only practicable means of removing the weapon or drug in question. Such a search may only be carried out at a hospital or other medical premises, or a police station in the case of a weapon, and it must be carried out by a registered medical practitioner or registered nurse unless it is not practicable. In addition, no person of the opposite sex who is not a medical practitioner or nurse shall be present. B. United States of America. While Canadian common law is derived primarily from British common law, as Justice Leroux Dubé noted in Coultier, it is nevertheless of assistance to look at the American law of warrantless searches of the person in considering the appropriate balance between the rights of individual being searched and the right of the police to search in Canada. The common law rule of search incident to arrest is expressed as follows in Corpus Juris, Volume 5 at page 343. After making an arrest, an officer has the right to search the prisoner, removing his clothes if necessary, and take from his person and hold for the disposition of the trial court any property which he in good faith believes to be connected with the offense charged, or that may be used as evidence against him, or that may give a clue to the commission of the crime or the identification of the criminal, or any weapon or implement that might enable the prisoner to commit an act of violence or effect his escape. As noted by Professor Lefebvre in his text Search and Seizure, a treatise on the Fourth Amendment, the American courts have upheld a wide variety of search procedures carried out in the context of warrantless searches as an incident to lawful arrest, including, quote, the placing of the arrestee's hands under an ultraviolet lamp, examining the arrestee's arms to determine the age of burn marks, swabbing the arrestee's hands with a chemical substance, taking scrapings from under the arrestee's fingernails, taking a small sample of hair from the arrestee's head, obtaining a urine sample from the arrestee, giving the arrestee a breathalyzer examination, swabbing the arrestee's penis, taking dental impressions from the arrestee, or taking pubic hair combings from him. The United States Supreme Court has considered the common law power to search incident to arrest on several occasions. In the United States in Robinson, the police arrested the accused for operating a vehicle after his operator's permit had been revoked. They conducted a, quote, pat-down, end quote, search of the accused's clothing and pockets and found a quantity of heroin on his person. The majority held that this search did not contravene the Fourth Amendment to the Constitution. In determining whether the police had the power to conduct a search, the majority reviewed the U.S. precedents and concluded that they had recognized a power to search a lawfully arrested person as an incident to arrest. Such power was found to be well-rooted in American legal tradition and served the practical function of removing weapons from an arrestee and preventing the destruction of evidence in his or her possession. In reaching its conclusion, the majority stated the following. The authority to search the person incident to a lawful custodial arrest, while based upon the need to disarm and discover evidence, does not depend on what a court may later decide was a probability in a particular arrest situation that weapons or evidence would be in fact found upon the person of the suspect. A custodial arrest of a suspect based on a probable cause is a reasonable intrusion under the Fourth Amendment, that intrusion being lawful, with the search incident to the arrest requires no additional justification. It is the fact of the lawful arrest which establishes the authority to search, and we hold that in the case of a lawful custodial arrest, a full search of the person is not only an exception to the warrant requirement under the Fourth Amendment, but it is also a, quote, reasonable, end quote, search under that amendment. The reasoning in Robinson was reiterated by the Supreme Court in Gustafson in Florida, a companion case to Robinson, which also involved a pat-down and a search of the arrestee's pockets upon arrest. The United States Supreme Court has not stated explicitly whether strip searching falls within the scope of the power to search incident to arrest. However, comments made in Illinois and Lafayette suggest that strip searches may be permitted as an incident to placing an individual in custody. The Fourth Amendment will not necessarily protect an arrestee against, quote, minor intrusions, end quote, into the body carried out as an incident to arrest, such as blood tests taken incident to arrest for driving under the influence of alcohol. Aside from the decisions of the United States Supreme Court, American appellate courts have considered the common law power to search incident to arrest and, in particular, whether it permits strip searches of the arrestees. Routine strip searches of persons held in custody for minor offenses have been held to be unconstitutional. On the other hand, legislation authorizing warrantless strip searches has been held to be constitutional provided that the search was based on, quote, individualized, reasonable suspicion that the arrestee was concealing contraband, end quote. In Swain and Spinney, the First Circuit concluded that strip and, quote, body cavity searches must be justified by at least a reasonable suspicion that the arrestee is concealing contraband or weapons, end quote. C. Canada. In contrast with searches of the person incident to arrest, there is a plethora of legislative provisions dealing with the searches of premises. In addition to Section 487 of the Criminal Code, which provides that reasonable grounds are required before a justice may issue a warrant authorizing the search of a, quote, building, receptacle, or place, there are many other provisions in the administrative and regulatory context governing the search of premises. The Law Reform Commission of Canada, in its working paper on police powers at page 20, remarked on the situation as follows. The restricted availability of powers of personal search in this context, i.e. the criminal law context, however, is due less to a heightened respect for personal integrity on the part of Anglo-Canadian lawmakers than to the historical association of the warrant with searches of private dwellings. Indeed, the development over the last 3 centuries of the warrant, with its safeguards against unjustified entry into private domains, has been accompanied by the accrual of relatively discretionary warrantless powers to search persons. Thus, searches of the person incident to arrest fall to be governed by the common law. There are relatively few reported pre-charter cases in Canada dealing with the lawfulness of searches of the person carried out as an incident to arrest. The lack of case authority on this issue is not surprising given the lack of effective remedies for unlawful searches, whether strip searches or other types of personal searches. Prior to the advent of Section 8 of the Charter, the only possible remedy for an unlawful strip search would have been a tort action for assault, battery, or false imprisonment. The cost of bringing such an action, the low amount of damages potentially recoverable, and the ineffectiveness of civil actions as a remedy when real evidence was seized through an unlawful search likely explains the dearth of case law. Recent cases illustrate that damage awards in tort for unlawful strip searches remain low, and the cost of bringing a civil action would far exceed the nominal damages awarded. See Nurse in Canada. One of the earliest Canadian cases referring to the power to search as an incident to arrest at common law is Goldschalk and Hooten, which concerned an action for the return of property taken by the police. In that case, the court adopted the statement of law concerning search incident to arrest as set out in Corpus Juris, quoted above in these reasons. The later case of Queen and MacDonald was an appeal of an acquittal of 2 police officers on charges of assault, arising out of a search incident to arrest. Justice Harvey reviewed the law on point, citing Gottschalk for the principle, quote, that the right to detain property found on a prisoner upon search has its limitations, end quote. In Yakishimin and Bolesky, another action involving property seized by the police upon arrest, the court again adopted the statement of the law set out in Gottschalk. In the Queen and Brezek, the accused appealed his conviction of having unlawfully assaulted a police officer engaged in the lawful execution of his duty for having bit and struck a police officer while the officer was attempting to search inside the accused's mouth for illegal drugs. Justice Robertson concluded that the search was lawful as an incident to the arrest, relying on the authority of Bessel and Leah, and dismissed the appeal from conviction. The case of Rhea Laporte and the Queen represents the high watermark in Canadian law as far as the degree of intrusiveness of searches of the person. In that case, the police sought a search warrant authorizing them to conduct a search of the body of Mr. Laporte for 1 or more bullets which were alleged to have been fired by police into Laporte's body during a holdup that occurred a year and a half earlier. The warrant issued authorized surgery upon Laporte to have the bullets removed and seized. Upon an application by Laporte to quash the search warrant, Justice Hugesson concluded that the warrant could not be justified under either the common law power of search incident to arrest or any of the statutory provisions of the Criminal Code. Accordingly, he set aside the warrant in order to prevent what he described as a, quote, grotesque perversion of the machinery of justice and an unwarranted invasion upon the basic inviolability of the human person, end quote. Another pre-charter case dealing with a highly intrusive personal search is Renyin and Antonenko. In that case, the plaintiff brought a civil action for assault and battery and exemplary damages arising out of a body cavity search carried out on the plaintiff to search for drugs secreted in his rectum. The search was carried out by a doctor at a hospital on the basis of the common law authority to search incident to arrest. Justice MacDonald dismissed the plaintiff's action and concluded at page 348 that the police in this case had not only the right but also a duty to conduct a search of the plaintiff for drugs and to seize any drugs found as evidence to be presented to the court. In making this search and seizure, the police are clearly authorized to use such force as is reasonable, proper, and necessary to carry out their duty, providing that no wanton or unnecessary violence is imposed. In the post-charter era, there are many examples of cases dealing with personal searches in general, and strip searches in particular, carried out as an incident to arrest. The greater number of strip search cases is at least in part due to the greater availability of remedies with the advent of the Charter, particularly the possibility of excluding the evidence under Section 24(2) of the Charter as a remedy for unlawful searches. However, the cases also suggest a disturbing trend towards strip searching detained persons as a matter of routine policy, regardless of the particular circumstances surrounding the arrest. While the constitutionality of strip searches incident to arrest has not previously been addressed by this court has addressed the constitutionality of a strip search and, quote, bedpan vigil, end quote, of a person detained at airport customs carried out pursuant to Section 98 of the Customs Act. In the Queen and Simmons and the Queen and Money, this court concluded that strip searches of travelers carried out under the customs legislation did not violate Section 8 of the Charter. However, this court also made it clear that its conclusion that Section 8 was not violated in the circumstances was based upon the, quote, unique factual circumstance, end quote, that border crossings present. The unique nature of the border crossing context was described as follows in the following passage from Justice IACOBUCCI's reasons in Moni at paragraph 42, quoting the majority reasons of Justice Gonthier in the Queen and Jacques at paragraph 18. The unique context that border crossings present was recognized by this court in the Queen and Simmons. Chief Justice Dixon, writing for the majority, said, "National self-protection becomes a compelling component in the calculus. I accept the proposition advanced by the Crown that the degree of personal privacy reasonably expected at customs is lower than in most other situations. People do not expect to be able to cross international borders free from scrutiny. It is commonly accepted that sovereign states have the right to control both who and what enters their boundaries. Given the unique context of border crossing searches, the reasoning in the customs case is not directly applicable in the present case. While this court has never pronounced on the lawfulness of strip searches conducted as an incident to arrest prior to the present appeal, it has made comments in Obiter concerning such searches in the cases of Bear and Coultier. The Bear case was concerned with the constitutionality of legislation that provided for the fingerprinting of individuals charged but not convicted of an indictable offense. In the course of concluding that the legislation was not in violation of the Charter, Justice Laforêt made the following comments at pages 403 to 404. As an incident to a lawful arrest, a peace officer has a right to search the person arrested and to make any property the officer reasonably believes is connected with the offense charged, or any weapon found upon such a person. See the Queen and Morrison. This authority is based on the need to disarm an accused and discover evidence. In the course of custodial arrest, an accused may be stripped of particular relevance, height, weight, and natural or artificial marks on the body, such as birthmarks or tattoo marks, may be used for purposes of identification. In Coultier, this court considered the common law power of search incident to arrest for the first time. The case involved a frisk or pat search of a motorist stopped for a traffic violation. Justice Leroux-Dubé, writing for the court, surveyed the British, American, and Canadian case authorities and concluded at page 180 to 181 that It seems beyond question that the common law, as recognized and developed in Canada, holds that the police have a power to search a lawfully arrested person and to seize anything in his or her possession or immediate surroundings to guarantee the safety of the police and the accused, prevent the prisoner's escape, or provide evidence against him. She noted, however, that while the existence of such a common law power is accepted, there is uncertainty as to the scope of the power. In Coultier, at page 186, Justice Leroux-Dubé stated the following three propositions in relation to the common law of search incident to arrest. 1. The police have the power to conduct a search at common law, but are not under a duty to exercise the power. 2. The search must be for a valid objective in pursuit of the ends of criminal justice, such as the discovery of a weapon or evidence. And 3. The search must not be conducted in an abusive fashion. A search that did not meet these criteria would be unreasonable under Section 8 of the Charter. Since Coultier, this court has addressed the constitutionality of the seizure of bodily samples at common law in Stillman. Justice Corey, speaking for the majority, held that the seizure of bodily samples, namely hair samples, buccal swabs, and dental impressions, was not authorized by the common law power to search incident to arrest. Such a serious interference with a person's bodily integrity required statutory authorization and could not be justified under the common law power to search incident to arrest. Justice Corey distinguished the situation in Stillman from other cases, such as Coultier, where searches incident to arrest have been found not to infringe the Charter on the basis that, quote, completely different concerns arise where the search and seizure infringes upon a person's bodily integrity, which may constitute the ultimate affront to human dignity, end quote. At the appellate and trial court levels in Canada, strip searches and even body cavity searches have been held to be lawful at common law as an incident to arrest. At the appellate level, the only court in Canada that has addressed whether strip searches incident to arrest are constitutional is the Ontario Court of Appeal. In the Queen and Morrison, the Court of Appeal concluded that a strip search of a female detainee arrested for theft and possession of stolen goods and cash did not violate Section 8 of the Charter, and that the evidence discovered in the search, namely marijuana, was therefore admissible. At page 442 of Morrison, Justice Dubin expressed the principles applicable to such searches as follows. As incident to a lawful arrest, a peace officer has the right to search the person arrested and take from his person any property which he reasonably believes is connected with the offense charged, or may be used as evidence against the person arrested, or any weapon or instrument found upon the person arrested, but he need not have reasonable grounds to believe that either such weapons or evidence will be found. It is the fact that the search of the person is made as incident to a lawful arrest which gives the peace officer the authority to search the person arrested. In two subsequent cases, the Ontario Court of Appeal held that strip searches did violate Section 8. In the Queen and Ferguson, the accused was observed for several hours at a house where police suspected drug trafficking took place. The police later stopped the accused's vehicle, searched his vehicle, and checked his name on CPIC. They then noticed a bulge in the accused's pants and discovered, after undoing his pants, that he was concealing a bag containing cocaine. The Court of Appeal ruled that the search violated Section 8 because it was conducted on the basis of a mere suspicion, rather than reasonable and probable grounds. Although the violation of Section 8 was found primarily on the basis that there was a lack of reasonable and probable grounds, the court also noted the intrusive method of the search. The court held that the Section 8 violation was serious, and the evidence should be therefore excluded under Section 24(2) and an acquittal entered. In the Queen and Flintoff, the accused was arrested for impaired driving and taken into the police station for a breathalyzer test. Prior to the breathalyzer test, the accused was strip searched as a part of routine policy of the police department and was not on the basis of any circumstances related to the particular case. After the strip search, the appellant was taken to the breathalyzer room and failed the test. The Ontario Court of Appeal concluded that it was unreasonable to strip search the appellant and the breach of Section 8 was serious. Accordingly, the court held that the breathalyzer evidence should be excluded and the decision of the trial judge dismissing the charge restored. At the trial level, there are numerous examples of cases involving strip searches performed as an incident to arrest. In some cases, the courts have concluded that the strip searches did not constitute a Section 8 violation, while in other cases similar searches have been held to violate Section 8. In the Queen and Stott, a strip search of an individual arrested for impaired driving carried out as a matter of routine police policy was held not to violate Section 8. Similarly, in the Queen and KDS, the strip search of a young offender at the police station as a part of normal police procedure following his arrest for possession of a stolen license plate was held not to be in violation of Section 8. Strip searches, accompanied by the threat of a subsequent body cavity search as an incident to arrest, have also been found not to infringe on Section 8. On the other hand, a routine strip search of a female accused arrested for theft and possession of stolen property was held not to be authorized by the common law of search incident to arrest. Also, in the Queen and Callan, a routine strip search conducted at the police station following an arrest for impaired driving was held to be unreasonable under Section 8 of the Charter. As these cases illustrate, there is inconsistency in the lower court decisions as to when strip searches are reasonable and when they are unreasonable under Section 8. D. The preconditions of a lawful strip search incident to arrest at common law. The appellant's position is that, given the negative impact of a strip search on an individual's privacy interests and psychological well-being, Section 8 should demand that at least probable cause be required to authorize strip searches and, absent exigent circumstances, a warrant. The intervener, African Canadian Legal Clinic, ACLC, agrees with the appellant that probable cause and a warrant requirement should be required for strip searches to be constitutional under Section 8 of the Charter. The ACLC says that given the negative stereotyping of African Canadians by police and the large number of African Canadians who are stopped and searched by police, a public process of obtaining a warrant is required to reduce the danger of racist stereotyping by individual police officers, who are more likely than a neutral arbiter to conclude that a strip search of a black person is appropriate. The intervener, Aboriginal Legal Services of Toronto, ALST, also advocates a regime of prior authorization for strip searches and submits that the common law does not authorize warrantless strip searches except in the most exceptional circumstances, such as where there is an immediate threat to the safety of police and the public or a threat of immediate destruction of evidence. For its part, the intervener, Canadian Civil Liberties Association, proposes 3 limits on strip searches incident to arrest. 1. Strip searches should be prohibited when less intrusive investigative steps are available. 2. Police must have reasonable grounds to conduct strip searches. And 3. Prior authorization in the form of a warrant should be required except in rare exigent circumstances. The respondent's position is that the common law authorizes strip searches and is reasonable within the meaning of Section 8. The respondent says that the restrictions on searches outlined by this court in Coultier and Stillman are adequate to ensure that strip searches incident to arrest meet the requirements of Section 8. The interveners, Attorney General for Ontario and the Canadian Association of Chiefs of Police, both agree with the respondent that common law authorizes strip searches and is reasonable. While the respondent and the interveners for the Crown sought to downplay the intrusiveness of strip searches, in our view it is unquestionable that they represent a significant invasion of privacy and are often humiliating, degrading, and traumatic experience for individuals subject to them. Clearly, the negative effects of a strip search can be minimized by the way in which they are carried out, but even the most sensitively conducted strip search is highly intrusive. Furthermore, we believe it important to note that the submissions of ACLC and ALST that African Canadians and Aboriginal people are overrepresented in the criminal justice system and are therefore likely to represent a disproportionate number of those who are arrested by police and subjected to personal searches, including strip searches. As a result, it is necessary to develop an appropriate framework governing strip searches in order to prevent unnecessary and unjustified strip searches before they occur. The law is clear in Canada that warrantless searches are prima facie unreasonable under Section 8 of the Charter. Where a search is carried out without prior authorization in the form of a warrant, the burden is on the party seeking to justify the warrantless search to prove that it is not unreasonable. Searches of the person incident to arrest are an established exception to the general rule that warrantless searches are prima facie unreasonable. In considering the constitutionality of strip searches carried out as an incident to arrest, it is still important to bear in mind that warrantless searches are the exception and not the norm in Canadian law. While characterized as an exception to the normal rule that a search warrant is required for a lawful search, however, warrantless personal searches incident to arrest are an exception whose importance should not be underestimated. The practical reality is that warrantless searches of persons incident to arrest constitute the majority of searches conducted by the police. There have been some legislative developments in Canada concerning specific types of personal searches, such as a breathalyzer and blood sample demands in the impaired driving context, and the taking of DNA evidence. However, these specific areas of legislation governing searches of the person are directed at the circumstances under which particular types of evidence may be obtained from a person. In this sense, they are more concerned with how and when particular evidence may be seized from a person rather than with the scope of police powers to conduct personal searches for evidence or weapons incident to arrest. In the absence of legislative guidance, it falls to this court to determine the scope of the common law power to search as an incident to arrest, and what the limits are to this power in the context of strip searches. This court has stated in many previous decisions that the common law must be interpreted in a manner that is consistent with charter principles. Where the common law is out of step with the charter, and it is possible to change the common law rule without upsetting the proper balance between judicial and legislative action, then the common law rule should be changed. While the common law authorities discussed above support the general proposition that a warrantless search conducted incident to arrest is permitted under the common law, the scope of this common law search power is less clear. Thus, the task in the present case is to delineate the scope of the common law power as it pertains to warrantless strip searches carried out as an incident to lawful arrest in a way that is consistent with the charter right to be protected against unreasonable search and seizure. As Chief Justice Lemaire stated in Castlake, because there are no clear limits on the power to search incident to arrest, it is, quote, the court's responsibility to set boundaries which allow the state to pursue its legitimate interests while vigorously protecting individuals' right to privacy, end quote. It is important to note that the discussion below relates only to the permissible scope of strip searches incident to arrest, as defined in these reasons. For greater clarity, if it appears during the course of a strip search that the detainee is concealing a weapon or evidence inside a body cavity, and the detainee refuses to cooperate, then in order to obtain the object in question, the police officer must likely exceed the realm of strip search and enter the realm of body cavity search. More intrusive searches of the person such as this involve a higher degree of infringement of personal dignity and privacy, as well as additional medical concerns, and, accordingly, a higher degree of justification will be required before such a search can be carried out. In addition, more intrusive searches will be subject to greater constraints as to the manner in which they may be reasonably performed. As noted by Chief Justice Dixon in Simmons, the different types of searches raise different constitutional considerations. The more intrusive the search, the greater the degree of justification and constitutional protection that is appropriate. The party seeking to uphold the validity of a warrantless personal search will face a lower burden in the case of a quick pat or frisk search than in the case of a highly invasive body cavity search. Given the purpose of Section 8 of the Charter is to protect individuals from unjustified state intrusions upon their privacy, it is necessary to have a means of preventing unjustified searches before they occur, rather than simply determining after the fact whether the search should have occurred. The importance of preventing unjustified strip searches before they occur is particularly acute in the context of strip searches, which involves a significant and very direct interference with personal privacy. Furthermore, strip searches can be humiliating, embarrassing, and degrading for those who are subject to them, and any post facto remedies for the unjustified strip searches cannot erase the arrestee's experience of being strip searched. Thus, the need to prevent unjustified searches before they occur is more acute in the case of strip searches than in the context of less intrusive personal searches, such as a pat or frisk search. As was pointed out in Flintoff at page 257, quote, strip searching is one of the most intrusive manners of searching and also one of the most extreme exercises of police power, end quote. Strip searches are thus inherently humiliating and degrading for detainees regardless of the manner in which they are carried out, and for this reason they cannot be carried out simply as a matter of routine policy. The adjectives used by individuals to describe their experience of being strip searched give some sense of how a strip search, even one that is carried out in a reasonable manner, can affect detainees. They are, quote, humiliating, degrading, demeaning, upsetting, and devastating. Some commentators have gone as far to describe strip searches as, quote, visual rape, end quote. Women and minorities, in particular, may have a real fear of strip searches and may experience such a search to be equivalent to a sexual assault. The psychological effects of strip searches may also be particularly traumatic for individuals who have previously been subject to abuse. Routine strip searches may also be distasteful and difficult for the police officers conducting them. In order for a strip search to be justified as an incident to arrest, it is of course necessary that the arrest itself be lawful. In the present case, there is no question that the arrest was lawful. While the appellant disputes the lawfulness of the arrest, the trial judge and the Court of Appeal concluded that there was reasonable and probable grounds for making the arrest, and we see no reason to dispute this conclusion. Thus, the first requirement of a valid search incident to arrest was met in this case. The second requirement before a strip search incident to arrest may be performed is that the search must be incident to the arrest. What this means is that the search must be related to the reasons for the arrest itself. As expressed by Chief Justice Lammer and Castlake at paragraph 17, a search, quote, is only justifiable if the purpose of the search is related to the purpose of the arrest, end quote. In the present case, the strip search was related to the purpose of the arrest. The arrest was for drug trafficking, and the purpose of the search was to discover illegal drugs secreted on the appellant's person. Had the appellant been arrested for a different reason, such as for a traffic violation, the common law would not have conferred on the police the authority to conduct a strip search for drugs, even if the police had knowledge of previous involvement in drug-related offenses, since the reason for the search would have been unrelated to the purpose of the arrest. In the circumstances of the present case, we conclude that the search was conducted incident to the arrest. The reasonableness of a search for evidence is governed by the need to preserve the evidence and to prevent its disposal by the arrestee. Where arresting officers suspect that evidence may have been secreted on areas of the body that can only be exposed by a strip search, the risk of disposal must be reasonably assessed in the circumstances. For instance, in the present case, it was suggested that the appellant might have dropped the drugs on the sidewalk or in the police cruiser on the way to the station, and that it was therefore necessary to search him in the field. As we discussed below, however, the risk of his disposing of the evidence on the way to the police station was low, and, had the evidence been dropped in the police cruiser on the way to the station, circumstantial evidence could easily link it back to the accused. In addition to searching for evidence related to the reason for the arrest, the common law also authorizes police to search for weapons as an incident to arrest for the purpose of ensuring the safety of the police, the detainee, and other persons. However, a, quote, frisk or pat-down, quote, search at the point of arrest will generally suffice for the purpose of determining if the accused had secreted weapons on his person. Only if the frisk search reveals a possible weapon secreted on the detainee's person, or if the particular circumstances of the case raise the risk that a weapon is concealed on the detainee's person, will a strip search be justified. Whether searching for evidence or for weapons, the mere possibility that an individual may be concealing evidence or weapons upon his person is not sufficient to justify a strip search. The requirement that the strip search be for evidence related to the grounds for the arrest or for weapons reflects the twin rationales for the common law power of search incident to arrest. Strip searches cannot be carried out as a matter of routine police department policy applicable to all arrestees, whether they are arrested for impaired driving, public drunkenness, shoplifting, or trafficking in narcotics. The fact that a strip search is conducted as a matter of routine policy and is carried out in a reasonable manner does not render the search reasonable within the meaning of Section 8 of the Charter. A strip search will always be unreasonable if it is carried out abusively or for the purpose of humiliating or punishing the arrestee, yet a routine strip search carried out in good faith and without violence will also violate Section 8, where there is no compelling reason for performing a strip search in the circumstances of the arrest. It may be useful to distinguish between strip searches immediately incidental to arrest and searches related to safety issues in a custodial setting. We acknowledge the reality that where individuals are going to be entering a prison population, there is a greater need to ensure that they are not concealing weapons or illegal drugs on their person prior to their entry into the prison environment. However, this is not the situation in the present case. The type of searching that may be appropriate before an individual is integrated into the prison population cannot be used as a means of justifying extensive strip searches on the street or routine strip searches of individuals who are detained briefly by police, such as intoxicated individuals held overnight in police cells. The difference between the prison context and the short-term detention context is expressed well by Justice Duncan and the recent case of the Queen and Obiter, which involved a routine strip search carried out incident to an arrest and the short-term detention in police cells for impaired driving. Justice Duncan noted that whereas strip searching could be justified when introducing an individual into the prison population to prevent the individual from bringing contraband or weapons into the prison, different considerations arise where the individual is only being held for a short period of time in police cells and will not be mingling with the general prison population. While we recognize that police officers have legitimate concerns that short-term detainees may conceal weapons that they could use to harm themselves or other police officers, these concerns must be addressed on a case-by-case basis and cannot justify routine strip searches of all arrestees. The fact that the police have reasonable and probable grounds to carry out an arrest does not confer upon them the automatic authority to carry out a strip search, even where the strip search meets the definition of being incident to lawful arrest as discussed above. Rather, additional grounds pertaining to the purpose of the strip search are required. In Coultier, this court concluded that a common law search incident to arrest does not require additional grounds beyond the reasonable and probable grounds necessary to justify the lawfulness of the arrest itself. However, this conclusion was reached in the context of a quote frisk end quote search, which involved a minimal invasive of the detainee's privacy and personal integrity. In contrast, a strip search is a much more intrusive search, and, accordingly, a higher degree of justification is required in order to support the higher degree of interference with individual freedom and dignity. In order to meet the constitutional standard of reasonableness that will justify a strip search, the police must establish that they have reasonable and probable grounds for concluding that a strip search is necessary in the particular circumstance of the arrest. In light of this serious infringement of privacy and personal dignity that is an inevitable consequence of a strip search, such searches are only constitutionally valid at common law where they are conducted as an incident to a lawful arrest for the purpose of discovering weapons in the detainee's possession or evidence related to the reason for the arrest. In addition, the police must establish reasonable and probable grounds justifying the strip search in addition to reasonable and probable grounds justifying the arrest. Where these preconditions to conducting a strip search incident to arrest are met, it is also necessary that the strip search be conducted in a manner that does not infringe Section 8 of the Charter. Parliament could require that strip searches be authorized by warrants or telewarrants, which would heighten compliance with the Charter. At a minimum, if there is no prior judicial authorization for the strip search, several factors should be considered by the authorities in deciding whether, and if so how, to conduct such a procedure. In this connection, we find the guidelines contained in the English legislation PACE concerning the conduct of strip searches to be in accordance with the constitutional requirements of Section 8 of the Charter. The following questions, which draw upon the common law principles as well as the statutory requirements set out in the English legislation, provide a framework for the police in deciding how best to conduct a strip search incident to arrest in compliance with the Charter. 1. Can the strip search be conducted at the police station, and if not, why not? 2. Will the strip search be conducted in a manner that ensures the health and safety of all involved? 3. Will the strip search be authorized by a police officer acting in a supervisory capacity? 4. Has it been ensured that the police officer carrying out the strip search are of the same gender as the individual being searched? 5. Will the number of police officers involved in the search be no more than is reasonably necessary in the circumstances? 6. What is the minimum of force necessary to conduct the strip search? 7. Will the strip search be carried out in a private area such that no one other than the individuals engaged in the search can observe the search? 8. Will the strip search be conducted as quickly as possible and in a way that ensures that the person is not completely undressed at any one time? 9. Will the strip search involve only a visual inspection of the arrestee's genital and anal areas without any physical contact? 10. If the visual inspection reveals the presence of a weapon or evidence in a body cavity, not including the mouth, will the detainee be given the option of removing the object himself or having the object removed by a trained medical professional? 11. Will a proper record be kept of the reasons for and the manner in which the strip search was conducted? Strip searches should only generally be conducted at the police station except where there are exigent circumstances requiring that the detainee be searched prior to being transported to the police station. Such exigent circumstances will only be established where the police have reasonable and probable grounds to believe that it is necessary to conduct the search in the field rather than at the police station. Strip searches conducted in the field could only be justified where there is a demonstrated necessity and urgency to search for weapons or objects that could be used to threaten the safety of the accused, the arresting officers, or other individuals. The police would also have to show why it would have been unsafe to wait and conduct the strip search at the police station rather than in the field. Strip searches conducted in the field represent a much greater invasion of privacy and pose a greater threat to the detainee's bodily integrity, and for this reason, field strip searches can only be justified in exigent circumstance. Having said all this, we believe that legislative intervention could be an important addition to the guidance set out in these reasons concerning the conduct of strip searches incident to arrest. Clear legislative prescription as to when and how strip searches could be conducted would be of assistance to the police and to the courts. 2. If the common law power to search incident to arrest permits a strip search, is the common law unreasonable? Given our conclusion that the common law does permit strip search to be conducted as an incident to a lawful arrest, the question is whether the common law is unreasonable in this respect within the meaning of Section 8 of the Charter. In our view, as interpreted above, the common law power to search incident to arrest conforms with the constitutional protection against unreasonable search and seizure contained in Section 8 of the Charter. The common law rule as delineated above governs the conduct of strip searches incident to arrest and ensures that such searches are only carried out where the police establish reasonable and probable grounds for a strip search for the purpose of discovering weapons or seizing evidence related to the offense for which the detainee was arrested. Furthermore, the factors set out above ensure that when strip searches are carried out as an incident to arrest, they are conducted in a manner that interferes with the privacy and dignity of the person being searched as little as possible. Attention to these issues will also ensure that the proper balance is struck between the privacy interests of the person being searched and the interests of the police and of the public in preserving relevant evidence and ensuring the safety of police officers, detained persons, and the public. We conclude, therefore, that the common law of search incident to arrest, which permits strip searches, does not violate Section 8 of the Charter. Was the strip search conducted in this case carried out in a reasonable manner? In light of the constitutional requirements set out above for a valid strip search incident to arrest, we are of the view that the search at issue in this appeal was unreasonable and violated the appellant's rights guaranteed under Section 8 of the Charter. In this respect, it is critical to underscore that where the reasonableness of a strip search is challenged, it is the Crown that bears the onus of proving its legality. It thus must convince the court on a balance of probabilities that either 1. Reasonable and probable grounds, as well as exigent circumstances existed, and therefore a strip search in the field was warranted and was conducted in a reasonable manner, or 2. That reasonable grounds existed, that the strip search was carried out at a police station and conducted in a reasonable manner. Because strip searches are of such an invasive character, they must be considered prima facie unreasonable. It is up to the state to rebut this presumption because it is in the best position to know and explain why the search took place and why it was conducted in the manner and the circumstances that it did. The onus rests upon the Crown in any case involving a strip search, as defined in these reasons. In the present case, the Crown sought to distinguish the first part of the search in the stairwell from the subsequent efforts to seize the plastic wrap from the appellant's buttocks after he was brought back into the subway shop. We are unwilling to accept such a distinction. The search in the stairwell whereupon the police pulled back the appellant's pants and underwear in order to visually examine his buttocks area, cannot be looked at in isolation. Rather, it must be assessed within the complete context of events that took place after the appellant's arrest. According to the definition adopted in these reasons, the first part of the search in the stairwell was a strip search, although it was clearly less intrusive character than the subsequent search in the restaurant. This visual inspection of the appellant's buttocks, in and of itself, interfered with his privacy, dignity, and integrity. The Crown's burden of proof in regard to the first part of this search is thus the same as that required to justify the subsequent search and seizures that took place in the shop. However, as discussed above, the more intrusive the search, the greater the degree of justification required and the greater the constraints as to the way it may be conducted. In this appeal, the Crown has failed to prove that the strip search of the appellant was carried out in a reasonable manner. More specifically, the evidence adduced at trial fell far short of establishing that a situation of exigency existed so as to warrant a strip search outside of the police station. The Crown asserted that this search was necessitated by Constable Ryan's observation of the appellant crushing what appeared to be crack cocaine between his fingers just after his arrest. In addition, this officer testified that he had made at least 12 narcotics-related arrests in his experience as a police officer, in which he discovered cocaine secreted by arrested persons in their buttocks or groin area. The Crown argued that these circumstances gave rise to reasonable and probable grounds for believing that the appellant was concealing evidence on his person. Further, it was submitted that the exigency arose from the risk that this evidence might be lost or destroyed if police waited to conduct the strip search until the appellant was transported to a police station. We find these submissions unpersuasive for the following reasons. First, Constable Theriault, the officer stationed at the observation post, testified that 51 Division Police Station was located on the corner of Dundas and Regent Streets, a 2-minute drive away from the shop where the strip search of the appellant took place. This fact alleviated any sense of exigency in this case. In our view, it seems highly improbable that the appellant, who was handcuffed, could have somehow surreptitiously riddled himself of the evidence concealed on his person during the very brief time it would have taken the police to relocate him to 51 Division. Had he succeeded in dropping the evidence on the sidewalk or in the police cruiser, it is difficult to conceive that he would have been able to do so unobserved, given the number of officers involved in his arrest. Furthermore, the circumstances surrounding the discovery of any drugs dropped close to the appellant would have provided strong circumstantial evidence of the appellant's connection to the evidence. As such, we conclude that this case was not one involving an urgent and necessary need to conduct a strip search in the field for the purpose of preserving evidence. The trial judge made no findings as to whether there was reasonable and probable grounds to conduct a strip search. He relied on the grounds for the arrest. As mentioned, Constable Ryan testified that in his experience, he had made at least a dozen arrests in which an arrested individual was concealing in his private areas. At the same time, this officer also testified on cross-examination that he arrested well over 200 persons dealing in crack cocaine. If these individuals were all strip searched, which is not evident in the record, he admitted to having found evidence hidden on an individual's private parts in merely 5% of drug arrests. If only a few of these individuals were strip searched, it raises questions, which ones and why. Constable Ryan thus knew that the chances of discovering evidence as a result of strip searching the appellant were quite slim. Other than Constable Ryan's personal experience, the arresting officers had no reasonable and probable basis for conducting the strip search in the restaurant. No information was given to them by Constable Theriault that the appellant had reached into his pants to remove any substances, nor had they ever witnessed such conduct themselves. There was no bulging or protrusion in the appellant's buttock area to suggest that he was concealing evidence. In the result, the decision to strip search was premised largely on a single officer's hunch, arising from a handful of personal experiences. These circumstances, coupled with the absence of exigency discussed above, compel us to conclude that the police officer's decision to strip search the appellant in the restaurant was unreasonable. Having so concluded, we should note, however, that there was some evidence suggested the possibility of concealment of narcotics. The appellant was arrested for trafficking after police observed him engage in 2 transactions involving what they believe was a narcotic substance. Further, the arresting officer found what they thought was crack cocaine under the table where another suspect was arrested. Constable Ryan also observed the appellant crushing a substance that looked like crack cocaine between his fingers during the arrest. Finally, Constable Ryan did have some experience, albeit in relatively few cases, with drug arrests involving suspects who secreted evidence in their groin or buttocks area. Taken together, these circumstances would have been sufficient to create a reasonable and probable grounds to conduct a strip search of the appellant at the police station. However, by deciding to carry out the strip search in a public restaurant rather than the nearby station house without appropriate safeguards in place, the police failed to meet a condition essential to the validity of an intrusive warrantless search. There was no reasonable and probable grounds to believe that this strip search had to be conducted with such urgency. In addition, the manner in which the strip search was conducted in the restaurant did not comply with the requirements of reasonableness contained in Section 8 of the Charter. The appellant was not given the opportunity to remove his own clothing, a measure that might have reduced the sense of panic he had clearly experienced. Rather, Constable Ryan pulled back the appellant's pants and underwear during the initial part of the search in the stairwell. He and Constable Powell then lowered the appellant's pants and underwear after the appellant was brought back into the main area of the restaurant. Also, the strip search was conducted without notice or authorization from a senior officer. The decision to search the appellant was made unilaterally by the arresting officers, in particular by Constable Ryan. Finally, the search was carried out in a manner that may have jeopardized the appellant's health and safety. Where the circumstances of a strip search required the seizure of material located in or near a body cavity, the individual being searched should be given the opportunity to remove the material himself, or the advice and assistance of a trained medical professional should be sought to ensure that the material can be safely removed. In this case, the plastic wrap was located between the appellant's buttocks. The police had no way of knowing whether it was physically lodged inside him in such a way that it could not be safely retrieved without medical intervention. Nevertheless, the arresting officers undertook to remove the package themselves through physical coercion and forceful probing and tugging at the package, and by instructing the appellant to let it out and to relax. The risk this presented to the appellant's health was made more acute by the fact that after the appellant accidentally defecated, Constable Powell retrieved a pair of rubber gloves that had been using for cleaning the shop's washrooms and toilets to continue his attempts at dislodging the package. The entire episode created as well unsanitary conditions in a public restaurant, which would have been avoided had the search been conducted in a less precipitous manner. The relevance of the appellant's resistance to the search also merits comment. At the voir dire hearing, Justice McNeely held that had the appellant relaxed and not attempted to retain the substance, the search would have been shorter and less intrusive. The respondent endorsed Justice McNeely's reasoning, relying on the British Columbia Court of Appeal's decision in the Queen and Garcia Gutierrez. In that case, police observed the accused reach into his mouth, remove something, and give it to another person, who gave the accused money in return. After arresting the accused for possession of cocaine for the purpose of trafficking, an officer grabbed his throat to prevent him from swallowing and breathing and instructed him to open his mouth. The accused refused, and a second officer punched him in the stomach. A majority of the Court of Appeal held that the search was reasonable, as it found necessary to preserve the evidence. In this regard, Justice of Appeal MacDonald held that the accused was in complete control of the violence inflicted upon him, since, had he simply opened his mouth, the police would have ceased applying physical force. We particularly disagree with the suggestion that an arrested person's non-cooperation and resistance necessarily entitles the police to engage in behavior that disregards or compromises his or her physical and psychological integrity and safety. If the general approach articulated in this case is not followed, such that the search is unreasonable, there is no requirement that anyone cooperate with the violation of his or her charter rights. Any application of force or violence must be both necessary and proportional in the specific circumstances. In this case, the appellant's refusal to relinquish the evidence does not justify or mitigate the fact that he was strip searched in a public place in a manner that showed considerable disregard for his dignity and his physical integrity, despite the absence of reasonable and probable grounds or exigent circumstances. In light of the foregoing reasons, we conclude that the manner in which the strip search in this case was conducted was unreasonable. It therefore amounted to a breach in the appellant's constitutional guarantees under Section 8 of the Charter. If the strip search of the appellant violated Section 8 of the Charter, would the admission of the evidence bring the administration of justice into disrepute under Section 24(2) of the Charter? As the appellant has already served his 14-month sentence in full, and because the courts below did not engage in a 24-2 analysis, we believe it is neither necessary nor useful for this court to determine whether the evidence derived from the illegal strip search would have been excluded at trial, and if so, whether a new trial should be ordered. In these circumstances, examining and ruling on 24-2 of the Charter would be a mere theoretical exercise. In preference to this analysis, our disposition rests on the premise that the courts below erred in finding the strip search of the appellant reasonable in the circumstances and consistent with Section 8 of the Charter, and consequently erred in allowing the impugned evidence to be admitted. These errors provide a sufficient basis for our conclusion that this appeal must be allowed. In light of all circumstances mentioned above, we conclude that an acquittal is the proper result. Disposition. For all the foregoing reasons, the appeal is allowed, and the judgment of the Ontario Court of Appeal is set aside. The appellant's conviction is thus overturned, and an acquittal is entered.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.